Time again to Ask the Attorney, and joining us now is Darrell Minton from Minton Marion Law Firm. Thank you so much for joining us.
Thank you.
Absolutely. Okay, we're going to get right to it. The first question is, if you're common law married, do you have to get common law divorced?
Well, no. When you get married, the ideal situation is stay married.
Exactly.
If you find some reason like you must get divorced, for example, if you want to get remarried, then yes, you do have to get divorced. But if you find a way to get common law divorce, do me a favor, call my office. Don't tell anybody, but tell me how to do it, because I want to patent that, because there's no such thing as a common law divorce right now. You have to file suit and go through the formal divorce proceedings just like with any other marriage.
So basically, if you are common law married, then if you guys break up, is it
you're
just
still
broken?
married.
Wow.
You are married forever until you get divorced. And if you get married to somebody else, that second marriage is considered void, but you can still be charged with bigamy for holding yourself out as married again to yet another person. So don't do that.
Yeah, okay, all right. So divorce is divorce. Okay. My husband married me under false pretenses and now has moved his ex-wife and her boyfriend in the house. Can I have an annulment and he pay for my moving expenses?
Well, it depends on how severe the false pretenses were. If it rises to the level of a severe fraud, you could, but there is also a caveat in the statute that says as long as you don't cohabitate after you discover the fraud, you can get an annulment. But if you're still living there with him, waiting on him to pay your moving expenses, then the annulment option is out.
All right, so that's once again not any kind of other divorce, but a divorce.
You're in for the old-fashioned expensive kind of divorce.
Okay. And what can you do about a parent at a football game that put her hands on your 9-year-old and starts yelling in their face?
Oh, find an usher, call the police. Putting hands on your child could be considered a civil and a criminal assault. An assault in civil is a harmful or offensive touch. So putting hands on someone's child would be a civil assault. But if there's no real damages, then it's going to be difficult for you to find an attorney to take that case on a contingency basis, and you're going to be stuck with simply going to the police and having them do that. They could file charges for a criminal assault against that other parent. You could file suit for intentional infliction of emotional distress, but again, what are your damages? It's not going to rise to the level of child endangerment unless the child is actually injured.
Okay, so unless the child is actually physically basically touched or hurt.
Well, she said put hands on, but sometimes people mean more than that when they say put hands on, but without more information, we can't tell what exactly she meant by this Facebook question, but generally, you need to find new seats.
Yeah, exactly. Okay, and of course, how can people get in touch with you?
Well, they can call me at this number back here on the screen. There's 783-0440, and we'd be happy to answer your questions if you'll give us a call.
All right, and of course, they can go to our website and ask the questions, and you'll be here in a couple of weeks.
And then they show up here in front of us.
Great. Thank you so much for joining us. We appreciate it. Great information.
Thank you.